This is Rob Bovarnick from Bovarnick and Associates, and this is another little vignette on tips in the law. Today what we're going to talk about is the wonderful world of bankruptcy. And when people think of bankruptcy, most often they think of liquidation. The company is out of business, and that happens a lot. That's Chapter 7, and I'll give you a real brief nutshell on Chapter 7 before I talk about Chapter 11. Chapter 7 is where a business shuts its doors. An individual by the name of a trustee is appointed. That person's job is to get the assets of the company, sell those assets, take the cash and distribute the cash among the creditors of the company. No muss, no fuss. Chapter 7s are over and done within a matter of months. Recently, Chapter 11s have made much bigger news in the last year. You may recall we've had Chrysler, we've had General Motors, and a whole host of others, be they Kmart or US Air. Chapter 11 is reorganization. Now, while a company can liquidate in a Chapter 11 just like it can in Chapter 7, most often when companies file in Chapter 11, the first thought is to try to reorganize, to shed dead weight, to come up with a new business plan as to how they're going to be successful going forward. The end game in a Chapter 11 bankruptcy case is this new business plan. And what it's called in the world of bankruptcy is a plan of reorganization. And the plan goes out to be voted on by all of the creditors. It's a thumbs up or thumbs down, and if it meets certain legal requirements, then that becomes the law of the land as between the new reorganized debtor and its creditors. If it's not voted up or down, then the case may convert into a Chapter 7 and the company goes through the liquidation proceedings. There are two other things that I want to briefly touch on with respect to a Chapter 11 bankruptcy. The first is something called the automatic stay. What that means is that creditors are not permitted to take any actions against the company while the company is in bankruptcy unless the court permits them to. So, for example, if your company was owed money by the company that's in bankruptcy and you'd started a lawsuit, that lawsuit stops until you get permission from the court, if you can, to go forward with the lawsuit. That's to provide the company with what's called breathing space, an opportunity for the company to catch its breath and to figure out what it's going to do in terms of its business plan or plan of reorganization. The other significant issue that comes up in virtually every Chapter 11 case are sales of assets. Now, there are two ways that assets can be sold outside of the ordinary course of business of the company, either through the plan of reorganization or through a section of the Bankruptcy Code called Section 363. And that's a standalone procedure where the assets are sold, and if you go through the 363 process, they are sold subject to what's called higher and better bids. And in essence, it's an auction. The notice goes out to anybody who might be interested, and then folks come into the court, if it's going to be in the court or the attorney's office, and they bid, and the highest bidder will be the winner. Those are a couple of issues in bankruptcy. There's one other thing I want to touch on, and that's attorney's fees. And as an attorney, you sit there and say, well, I'm sure that, Rob, that's what you are most interested in. And it isn't for a good reason. A lot of the cases I work on are small businesses. I operate under the assumption that about 75% of small businesses will fail. So if a client comes to me, I need to do as much due diligence to make sure the exit strategy is viable. Otherwise, I will end up with a bad receivable. One of the other things that I do is I try to give an estimate to the company as to how much it will cost in professional fees. Historically, I have found that the professional fees run about 4% of revenue. So if a client comes in and say that they did $2 million in revenue the prior year, I will say to them that it will probably run between $75,000 and $100,000 in fees. It's very expensive, which is one of the reasons why the Chapter 11 case should only be gone into as a last resort. If you can try to work out your issues with creditors beforehand, that is a much better way, it's much safer, and it's much less expensive. And that's it for today. I look forward to talking to you again soon.